Thank you very much, Mr. Chairman, sir. Sir, I rise to oppose the bill. Even at the time of the introduction of the bill, I have vehemently opposed the introduction of the bill and I have demanded a division in this house, and there was a division also. At that juncture also, we were under the impression that the Honorable Minister and the government may rethink their political position so as to send this bill to the Standing Committee for close scrutiny. Unfortunately, the Honorable Minister now comes and moving the bill for consideration and passing the bill. It is quite unfortunate because this is a very contentious bill by which the constitutional provisions are involved, human rights violations are involved, and so many ramifications, repercussions are there. Such a controversial, contentious bill have to be gone through the parliamentary scrutiny by a committee, either by a select committee or a standing committee, but without sending that bill, even after having a division in the House, 120 in favor and 58 against the bill, such a division was there in the House. Even after that, the government is not willing to send the bill to the scrutiny of a standing committee. Is quite unfair on the part of the government. That is the first point which I would like to make. Sir, I am opposing the bill mainly on three grounds. Number one, this is the total clear violation of the fundamental rights enshrined in Part 3 of the Constitution, number one. And number two, the right to privacy ensured by the Supreme Court in Puttaswamy's case is totally violated, totally abrogated, number two. And number three, the human rights violation or the human rights which has been declared in the UN Declaration of Human Rights, that is also not being respected in this case. These are the three main grounds by which I strongly oppose this bill. And again, I request the Honorable Government, the Minister, please have a close scrutiny of the bill by sending to Standing Committee or Select Committee or Joint Committee, whatever be according to the women's funds of the government. Sir, what is this bill? The Criminal Procedure Identification Bill is to replace the Identification of Identification of Prisoners Act of 2020. Sir, the 2020 Act of the British India government law is more liberal than this. Sorry, I'm corrected. 1920 bill is more liberal than that of this bill. And when we are in the reformed democratic era, we are making the law more rigorous and stringent and giving unfettered authority to the police officials, especially the law enforcement agencies, and in respect of data collection and analysis, and that too at a time when the data protection bill is pending for consideration before the parliament, and the scrutiny is over. The standing committee has already submitted the report. Unfortunately, the government is not coming with the data protection bill for consideration passing. The violation of right to privacy, Puttaswamy judgment, it has already been stated. In the judgment, it is very clear that the Puttaswamy judgment made it clear that the law must be tested on the grounds of necessity and proportionality, purpose limitation, storage limitation, etc. These are the guidelines by which the Puttaswamy judgment is saying regarding the legislative process. But nothing is being attracted in this case. So the right to privacy, Article 21, no person shall be deprived of his life and personal liberty except in accordance with the procedure established by law. That is being taken away, number one. And number two, sir, unchecked, unfettered powers to have the surveillance, police surveillance. I'm not going to the definition of the measurements, well enunciated by Manish Tiwari ji, and it is expanding and widening the scope of measurements. Even DNA can be taken from a person, and also further storage for a period of 27 years. Sir, the clause 3 of the bill, that is a contentious bill, that who has been convicted, who has been arrested, and any person who is detained by the preventive detention law. Sir, what is the definition of convict? I am seeking a clear-cut answer from the Honorable Home Minister. What is the definition of the convict? If you are not wearing a mask, if you are violating the lockdown guidelines, you will be convicted. Even a penal conviction for 1,000 rupees is a conviction. There is no definition in the bill. Sir, please. I'm fully within the scope of the bill.
You made this point when you resisted.
Yes, sir. So my point is, who is a what was the original bill, 1920 bill? The 1920 bill is very clear that those rigorous imprisonment for 1 or more year, then only it will be a conviction. Here, what is the conviction? Even if you are not wearing the mask, you are being convicted for 3,000 rupees as the fine, then your DNA can be taken. Sir, the police officer, head constable is the officer, and the jail warden is the officer, for which also I have given the amendment. And last point, sir, excessive rule-making power is given in the delegated legislation by virtue of clause 8 of the bill. Manner of taking measurements, collection, storing, and sharing of all these things, and also this is also excessive delegated legislation, sir. And also it is against the recommendation of the 87, the Law Commission's recommendations has not been considered to. In all these aspects, I will once again urge upon the government, this is a draconian legislation to take away the democratic, individual, fundamental rights of the citizens or persons of our country. So please send this bill to the standing committee, and I strongly oppose with this.
K. Subrayan.